Thank you for joining us for this series. I am going to take a moment to go over some accessibility guidelines with everyone. And after that, I will do the introductions and we will officially begin. The Office of Equity is committed to hosting accessible events that promote belonging, justice, dignity, honor, and respect. Language and communication services provided today include the CART that you see, Communication Access Real-Time Translations. I will repost the CART link in just a moment. Let me get through all the accessibility issues, not issues, excuse me, guidelines, and then I'll repost that link in the chat for everyone to see. You will click on the transcript CC icon at the bottom of the screen if you need the CART captioner. Again, the link will be in the chat in just a moment if you can't see it already. If you can, feel free to access it. We have two ASL interpreters joining us today. Amanda is one, and the other one is, I believe, Heidi. Hold on one second. Let me verify.
Correct, Tanisha.
Yes, Heidi is the other. Thank you all for your patience. Okay, when we get to the Q&A portion of the segment, feel free to raise your hand and then you will be unmuted so that you can ask your question. The Q&A is open, so if you don't want to speak, you can also type your question in the Q&A and we'll get to it during that section of the presentation. We ask when it's time for Q&A that you speak clearly and slowly so that the ASL interpreters can interpret what you're saying and the CART captioner can capture everything that you're saying as well. We are happy today to have with us again, returning, Justice G. Helen Whitener, who was initially appointed in April 2020. Excuse me, 2020. I said too many 20s. And subsequently elected twice by the voters of Washington State Supreme Court. Prior to her appointment to Washington State's highest court, Justice Whitener served as Pierce County Superior Court judge. Justice Whitener also served as judge on the Washington State Board of Industrial Insurance Appeals and as a pro temp judge in Pierce County District Court and the City of Tacoma Municipal Court. Before becoming a judge, Justice Whitener litigated both civil and criminal cases for 14 years, first as a prosecutor and a defense attorney, and later as a managing partner of the law firm of Whitener Rainey Ritt PS. Justice Whitener is the first Black woman to serve as Washington State Supreme Court, first Black woman to serve on the Washington State Supreme Court, the fourth immigrant-born justice, and the first Black LGBTQIA plus Supreme Court justice in the nation and the state of Washington. Justice Whitener identifies as a person with a disability and speaks often to local, national, and international organizations on human rights and access to justice. Justice Whitener is well recognized by the legal community for her commitment to justice and equity. Her impactful career has been marked by a series of distinguished awards across several years, reflecting her significant contributions. Her most recent honors include the 2025, I am probably going to mispronounce this, unfortunately, but I'm going to do my best, Anshel Massey Award of Distinction from the Cardozo Society of Washington State. So we are indeed honored to have Justice Whitener here with us today and returning with us again we have Joslyn Nelson, who is the Senior Court Program Analyst for Washington State Supreme Court Disability Justice Task Force at the Administrative Office of Courts and oversaw the first in the nation study on disability justice in the courts. She has a BA in political science and U.S. history from Evergreen State College. She previously was the court program analyst for the Board for Judicial Administration, Electronic Monitoring with Victim Notification Technology Program for Domestic Violence Victims. Joslyn, who has a disability, and family members with a disability brings both a personal and professional passion to her work, informed by a deep understanding of intersectionality and how justice and accessibility affect every aspect of life for individuals with disabilities. She speaks to universities and state agencies on disability justice. And as the founder and first chair of the State Disability Inclusion Network, our BRG, excuse me, BRG stands for Business Resource Group. So our Washington State Business Resource Group. Thank you, Joslyn, for joining us again. And now I will hand it over to both of these individuals to begin this week's presentation.
Thank you, Tanisha. Don't feel bad. I can't pronounce the name of that award either. So every time someone tries to do it, I chuckle. So welcome back, everyone. And I'm really excited to be with you today because Joslyn is going to lead us through something that is really important, I think, before our courts, and that's domestic violence and how we handle it. But because we're coming at this through disability lens, I think you're going to be really impressed with the information that you're going to get today. October carries significance for our work in the courts because it is both Domestic Violence Awareness Month and National Disability Employment Awareness Month. And together, they remind us that survivors with disabilities often face higher risk of violence and also greater barriers in every area of life, including work, safety, and access to justice. Although domestic violence impacts individuals of all genders, the majority of research focuses on violence perpetrated by males against female victims. While recognizing that domestic violence may manifest itself differently based on the gender of both the victim and the perpetrator, I want you to delve into some of the differences as you hear the presentation today. We will try to use gender-neutral language to the extent possible. So one tool available in Washington is the Hope Card program. And these wallet-sized, they're like wallet-sized cards that survivors of domestic violence can carry all of their pertinent information in. So this is a relatively new program. And when I say the pertinent information regarding domestic violence, we're talking about like their name, the name of the person who's restrained, and their identifying information, which comes in real handy when a law enforcement officer, for example, stops a car and there's a woman and a man in that vehicle, and the man has a restraining order to not have contact with this woman. Now, I take the time in saying that because I'm saying the man is the one, the batterer, and the woman is the victim. And the reason I said the man is the one who is restrained from having contact with the female is to set up the context in regards to domestic violence. When I handled domestic violence in the trial level court, I made it clear to the defendant that this is a restriction on your ability to do the following things. Because many times they come back to the court on a violation hearing And they say, but she invited me or she allowed me to see her. No, I'm prohibiting you from having contact with this person. And this person doesn't have the ability, because you'll find out that most of the time, they're not the one making the contact, it's the batterer. But this person, the victim, does not have the ability to undo my court order or any court order prohibiting you from having contact with them. So the Hope card has the identifying information of the batterer. It has the restraints, the conditions. It has the name of the person or persons protected, because sometimes children are also protected. And it has the date it was issued and the expiration date. This Hope card really assists not just law enforcement officers out there, but it was required for so long because many times they had no idea. They had to go check their system in their vehicle to figure it out. So the Hope Card is a wonderful program. So it's mainly utilized by survivors with disabilities as well as survivors of everything else, but domestic violence. It reduces barriers and make enforcement more immediate and effective. And in DV cases, the role of the court is to ensure that protections are practical, accessible, and enforceable. So every survivor has a real pathway to safety. So we thank you again for being here. We're focusing today on how Washington's civil and criminal systems serve survivors of domestic violence, especially survivors with disabilities. And Joslyn, if you'd like, you can discuss the Washington State Coalition Against Domestic Violence. They did a one-day census, and my understanding is 2,970 survivors' safety needs were met in a single 24-hour period, while 482 requests went unmet. That's unmet safety in just one day. What does that say?
That says that we have a domestic violence problem here in Washington State, but not only that, we just also don't have enough law enforcement either. And that is something that, I know that in the news there's been a lot of discussion about law enforcement, but they're predominantly the ones that are the first on the scene for a domestic violence case.
Mhm.
Um,
Do you think they're trained adequately?
Some are, and some have basic training. They're depending on the jurisdiction of each county. I know Yakima County spends a lot of time um, providing thorough training to their police department. So it is going to be based on funding, um, size of police departments in rural counties. They have maybe one individual, maybe two officers in that area. And when you're in a rural area, there's easier places to hide, there's easier places to go and be. So, it's very difficult, especially within the 39 counties, and most of them being rural here, to monitor everything
And
effectively.
especially with a disability in that area. So I saw that law enforcement reports confirm the scale in 2022. 45.9% of all crimes against persons in Washington were DV related. In 2023, it went up to 47.9%, and nearly half of serious person crimes in our state are tied to domestic violence. For survivors with disabilities who face the highest rate of violence and the most barriers to accessibility, it is not optional. It's determinative of whether protections are real. So we'll explore the barriers, the data, and what courts can do to strengthen protections through a disability justice lens. So why does this matter, Jocelyn?
Sorry. So why
I
does this
mean, it could
matter?
be,
Nationally,
go
it
ahead.
matters on several fronts. Go ahead, Justice Whitener.
I mean, it seems obvious, right? But give me some stats.
So, as we see nationally, and I'm going to speak with women with disabilities experience, and I'm going to use the intimate partner violence. But I just also want a prevalence that it's not just intimate partner violence. It can be caregiver violence. It can be parent violence. It can be multiple things that qualify for domestic violence.
Mhm.
So I just want to put that out there. But for this particular stat, the intimate partner violence at rates at 40% higher than women without disabilities. And the Bureau of Justice Statistics confirmed that people with disabilities face 4 times higher victimization rates than non-disabled peer. And this was data from 2019. Here in Washington State, DV isn't isolated. It makes up, as Justice Whitener said, nearly half the crimes against persons reported by law enforcement. And also, when it comes to youth, youth at the risk starts early. Washington State's Healthy Youth Survey showed nearly 1 in 5 high school girls and 1 in 10 boys reported unwanted sexual contact. And then with youth with disabilities are at a double the risk compared to their peers. So this isn't just have to do with the ADA compliance. It's about the legitimacy of our court. Survivors can't access justice if they can't access the process of the of how the courts operate.
So you said a mouthful and why this
Yeah.
matters, which led me to look at Washington State's domestic violence rule statutes. And I looked at the intent behind the domestic violence statute, and it looks like the legislature, the intent was that the official response to cases of domestic violence shall stress the enforcement of the laws to protect the victim and shall communicate the attitude that violent behavior is not excused or tolerated. So that's just one part. Now, you've also heard Jocelyn and I use the word domestic violence. And there's a colloquial meaning regarding domestic violence, but I'll give you the legal meaning. Domestic violence includes, but is not limited to, any of the following crimes when committed either by a family member or household member against another family or household member, or one intimate partner against another intimate partner. And we're talking about Class A felonies down to misdemeanors. So assaults in the first degree, rape in the first degree, criminal trespass, kidnapping, all of these can be domestic violence related crimes, rape, residential burglary, stalking. Those are the ones that you're probably most familiar with. We also look at what is a family or household member, and that means adult persons related by blood or marriage, adult persons who are presently residing together or who have resided together in the past, and persons who have a biological or legal parent-child relationship, which includes step-parents, stepchildren, grandparents, grandchildren. So not everybody or every crime gets a domestic violence designator. There are things the court looks to and looks for to determine. Intimate partner has its own meaning. Can be a spouse or domestic partner, a former spouse or former domestic partner, persons who have a child in common regardless of whether they have been married or have lived together at any time, adult persons presently or previously residing together who have had or have a dating relationship, and persons 16 years of age or older who are presently residing together or who have resided together in the past, or who have or have had a dating relationship, or persons 16 years of age or older with whom a person of 16 years of age 16 years of age or older has or has had a dating relationship. And there are many, many other terms when you get into domestic violence that the court looks at in determining what exactly are we dealing with. In regards to even the designator, when someone is convicted of a crime that gets that designator, they also are looking at possible extended sentencing conditions or time. So why it matters, we just found out. I'll turn it over to you, Jocelyn, for some data.
And some data that we're going to go over, go through the slides briefly to kind of match a little bit what Justice Whitener was saying. But here are some of the civil, because there's also a civil component to DV, because we also know that a lot of DV victims will not go the route of criminal. So there's still two directions that a person can get a protection order, and that's either through the civil or criminal matter. So technically, they're not convicted of DV, but it's still on their slide. So I'm going to start with slide 4 here on civil and criminal courts. As again, DV charges prosecuted under RCW 1099 and then RCW 7105. Those have a little bit different directories and how you get that. But we do know that the volume is very high. And in 2022, more than 17,000 civil protection orders were filed in Superior Court, and also another 17,000, I think I said 17,000 civil protection orders were filed in Superior Court, and then an additional 7,500 in District Court. And these are just civil protection orders. These aren't criminal protection orders. And so that tells you that a lot of people aren't reporting to the police either, and because of the fear aspect that goes along with it. In 2024, our Superior Court statewide reported about 21,500 civil protection orders filed under the new consolidated RCW 7.105. Alongside all of this, we still have the criminal DV prosecutions, and this means Washington courts are also processing on the criminal side around tens of thousands of DV related cases each year. So the scale reinforces why I'm going to use the terminology DVPO, which is Domestic Violence Protection Order. Uh, Intake hearings and enforcement are absolutely essential. So we have a huge issue with domestic violence here within Washington state. Some of the things I just want to talk about a little bit because I think this gets brought up for survivors with disability. I want to kind of give a what coercion might look like for DV survivors with disabilities, because I think the public overall might look at something and not realize that it's actually coercive control. And so for people with disabilities, it could take like the courts might miss somebody withholding their medication from them, blocking access to mobility aids, denying interpreters or controlling communication devices, withholding their disability paychecks, withholding food, also withholding any type of caregiving that might need to be given. Sometimes if it's not a disability that is overtly apparent. It could be controlling by monopolizing their vehicle, their money. So there's a lot of tactics that I think that get missed when it comes to people with disabilities.
Which brings me to something I learned when I first started as a Rule 9 attorney, which means you're still in law school and you're under the supervision of a barred attorney. And it was with the City of Tacoma Prosecutor's Office. And I learned about power and control. And power and control seems to be an overriding issue when you're dealing with domestic violence and rape cases. Would you agree? Is that still the framework that these types of cases are viewed through?
Yes, I would say power control dynamics are very large within DV, but also within the disability community in general. And I'm going to say that in the aspect that for people with disabilities, and I'm only going to speak from my perspective, but because you go through life with a disability, you automatically, society tells you you're less than. And they reinforce that authority always knows more than you. And
Mm.
so when you couple that with a thought process with a disability, sometimes there's a lot of passiveness that happens. And so there's a lot of individuals who feel that they don't have control. And so they will wind up in a situation that mirrors that thought process that they have about themselves. And that's unfortunate. With DV, that individual disabilities actually have one of the highest DV counts. That tells you something is going on, especially if they're not being able to seek justice through the courts.
So, in a prior session, we talked about the intersectionality of things. And as you're talking now about domestic violence, I'm seeing layers. And the more layers you have, is the more complex your circumstance as a person with a disability becomes. So
That's
I want to read um, what we would call maybe a disclaimer or sensitivity acknowledgement slide at this time. Because today's content addresses domestic violence and disability. And as we get more into this and share some stories, some of you could experience triggering, and it may become difficult, or the subject matter may be difficult, and that could trigger something. So I ask, first and foremost, we both do, we ask that you protect yourself. If it is too much for you, it's okay to step back. But we just want to make sure you understand that. And before we go any further and talk about domestic violence, I believe next would be in Washington State. Would that be where we're going next, Jocelyn?
We did briefly talk about that already. So right now I just want to give a national overview too, because I want to make sure that we're bringing men into the conversation. And so national data around domestic violence for men is about 1 in 4 that's reported with an intimate partner violence situation. And we do know that there's stigma around men reporting domestic violence. And so I want to make sure that it's also highlighted that men with disabilities also experience intimate partner relationships at a higher rate than men without disabilities. So once you add the disability label to a partnership, the likelihood of domestic violence does increase with your disability.
No matter if you're male or female, if if you're not disabled, it's really your gender. So we see more men um, battering women. But if a person is disabled, for example, a disabled man, and their intimate partner or spouse, what I'm hearing is that man can be in the same situation as we normally view women because of
That's
that
correct.
disability. So that power and control dynamic comes into play again. Wow. Okay.
And that's a societal viewpoint of viewing people with disabilities less than. And so that
Right.
automatically puts that power control situation up once that disability is brought into the situation.
Okay. I'd like
Um,
the court had a case, and I want to set the framework. Um, in regards to this case, it's a published opinion. It's State v. Abdi Issa, and it was 2022. I was on this court at the time. And I want you to see, like Jocelyn was saying, it can manifest itself, the domestic violence, in so many different ways. So this is a case where this woman, Julie Fairbanks, began dating Abdi Issa. And shortly after, she moved to Seattle with her dog. They started dating. Mona, her dog's name was Mona, was a small Chihuahua and Dachshund mix. The woman testified she was close to her dog. And Abdi Issa had a history of disliking the dog. He was abusive towards the woman and her dog, even threatening to kill them both. One evening in the Seattle International District, he insisted that she let him take the dog on a walk. She objected, but he ignored her and left with the dog. She felt powerless, claiming it didn't matter If he wanted to take her on a walk, he was going to do it anyway. Not long after he left, he called her claiming that the dog had gotten out of her harness and that he could not find her. She did not believe him, as her dog had never gotten out of her harness before. He refused to tell her anything else. She began to panic after she heard the dog yelping over the phone. Around that same time, two individuals heard a sound of great distress. They followed the sound and saw him beaten and making brutal stabbing motions towards the dog. They said he kicked the dog so hard that she went up into the air and flew into the bushes. Each time the dog was struck, she made a screeching, screaming, pained, awful sound that was at last followed by silence. While one of the individuals that called the police yelled at him, Abdi Issa, to stop hitting the dog, he turned towards them and yelled, "Do you want to get some?" When one of the individuals once again told him to stop, he walked away. Police were called, they responded. I'm jumping ahead. At trial, the individual testified. Now, this is the individuals that were not related to him. That she was very upset by the incident. And when the police arrived, this individual was hyperventilating and having a panic attack. The person cried as she explained to the officers what she saw and where she had last seen the dog. That person suffered a severe panic attack that night and continued to experience flashbacks in the following week. I want you to understand and keep that framework in mind, because domestic violence doesn't necessarily have one victim. In this case, there were literally 4 victims, but only one could get the domestic violence designation. And that one individual was the woman who lived with him, right? The dating relationship. That's why I read what Washington looks for. But when I look at the fact pattern, the 2 individuals on the street that saw this and called it in were victims as well, but it would not be considered domestic violence. So as you move through scenarios, keep that in mind. Domestic violence has specific meaning, right? The other thing I wanted you to get from this is the 2 individuals who were not connected to this pet experienced, what did she say? She cried. She was hyperventilating, severe panic attack. This is someone who does not have a relationship with the dog. How do you think the woman who was in that dating relationship, whose dog that is, was made to feel? Because the dog did die. With that frame of reference, going forward, when you hear these stats and you hear the information, and then think about it, if the person was a person with a disability, and let's say this was their care dog, you see the power and control dynamics here? And that was not the worst kind of domestic violence case that we have. Joslyn.
Yeah, thank you, Justice Whitener, for that. There's a couple of highlights, and I know I've shared this slide before when it comes to domestic violence and individuals with disabilities, because part of the problem, and I know I've talked about this in depth in almost every series, is the word credibility. Once you say you have a disability, your credibility goes down, and the likelihood of you ever getting justice is very low. And so when I look at these crime data, and unfortunately they have not been updated through the Bureau, but it still rings very true even today. If you look up to the upper right-hand part of the screen, and I'll read it out loud, violent crimes reported to the police for people with disabilities was 47%. People charged in the offense, well, that went down to 22%. People convicted of the offense dropped down to 9%. And that comes back to the word disability is linked to credibility. And I also want to highlight that survivors with disabilities are 70% more likely to face high impact violence like strangulation and or weapons being used. But I also want to highlight a bigger fact is 70 to 85% of abuse cases against disabled survivors go unreported.
Mm.
So for courts, this means the cases that come before you are only visible fraction of a much larger crisis that we're experiencing within the court system.
Mhm.
Mhm. And here in Washington, unfortunately, we see that this population is really high. Zooming in, half of female homicides here in Washington state are killed by intimate partners. Another study found that 12.9% of all violent deaths between 2015 and 2020 were DV related. And then this also tells us that 12% of violent deaths from 2015 to 2020. The problem here in Washington state is that there's no state, the data is not disaggregated for disability.
Mhm.
And that is becoming a critical gap because we can't tailor programs around individuals with disabilities. DV shelters can't remain open and they have to turn a lot of disabled individuals away because this critical data is not being tracked.
So,
Also, I'd like to just add one more thing,
yeah.
is that DV is both widespread and lethal for disabled individuals. So
Mhm.
it is incredibly important that we start looking at a lot of these situations that are going on.
Because that's something I was going to ask you. Um, Someone in a wheelchair, for example, um, in order to get away, goes to a shelter. And what I heard you say is the shelter could literally turn this person away if they're at capacity.
If they're at capacity or they're not accessible. So we want to look at accessible not just for
Mm.
the mom or the woman that's getting away or the man that's getting away. What if it's the child that has a disability and they have medical equipment that they have to take with them because their child needs medical equipment? These shelters are not set up to take in families with disabilities to the capacity that needs to be there. And this is a critical issue that we're running into because we don't have the data that tracks disabilities separately. Most of the data that is pulled is from national data and then from the data that we have from Washington State. And so what we're you looking at as a whole is that we see the data is very high in Washington State for DV offenses. We know the data is high for people with disabilities. We also know that there's critical gaps within services being provided.
Which flows right into something else that I've observed on DV cases, and that is the society always asking, so why didn't she leave? And here I'm hearing, even if she did leave, goes to a shelter, no space for her or her child, or space for her and not her child. Where is she to go? She goes back. That's the cycle. Am I seeing this wrong, or because I'm
No, you're
putting the
seeing this.
pieces together?
You're seeing this correct. And so not only is there the shelters, but then when they enter the court system, there's a power
Mhm.
dynamic within the court system that these individuals have to go through. And so we also have that. That's also there. The resources aren't always available because there's not enough data or funding generally for DV shelters and resources. But when you add an additional component of disability, the resources are even more scarce. And so it's something that we are in the state not tracking because we all know that data leads to funding, and that is an
Yeah.
area that's not being tracked,
Mhm.
unfortunately. Um, and
So,
and we also look
mm,
at, yeah, sometimes these children are then taken into foster care and then they're taken into DCYF because the mom can't leave because if the parent is disabled, they're then becoming reliant on their
mm.
perpetrator.
Mhm. I want to backtrack before we move forward. You used the word credibility, and I think we shared in a previous session when our disabilities manifested themselves, how people change. For me, it was at 16, literally losing the use of my right side, and people all of a sudden, because I'm in a wheelchair, all of a sudden start talking louder and slower and simple, long phrases as if something happened to my mind. My back was literally giving out, so my side gave out, but not anything intellectual. So even in a non-criminal space, your capacity, your competency is questioned. Now let's move that to a person with a disability in a DV relationship, power and control, and they come before the court because the individual that was the batterer is arrested and charged. And this person has to go through the trauma of relaying their abuse within the courtroom at a trial, and their credibility is questioned. Because you have to remember, too, domestic violence doesn't usually happen the way it did in Abdi Ister's case, where you had individuals out in the public observing the abuse, and the abuse is connected to his intimate partner's pet. It's usually behind closed doors. It's a he say, she say. So credibility is huge. And individuals with a disability is already questioned. And now we have them in the court being questioned as to something that happened to them. How can we even try to address that?
There's a couple of things to address that, and I think we're going to go that in a little bit further of the
Mhm.
slides because there is a bias within the courts too when we view people with disabilities. One of the other things I want to point out, because we did talk briefly about the youth, is also down here in the little asterisk marks, is we also don't have Washington State does not track DV data for disaggregated by disability and youth. We only track it by youth. So
Mhm.
there is a lot of data situations that we are also not tracking, but we also have a high DV rate of youth here in Washington State too.
Mhm.
It's pretty prevalent.
Before you
A
move
little
on,
bit,
Joslyn,
yeah.
one more thing. We have been discussing domestic violence, but we've used physical disability to seen visibility. What form can the psychological disability take in a DV situation?
Um, it can be coercive control. So if it's not, there's still physical disabilities going on. It also is going to depend on the type of disability. Many years ago, I was an advocate. I was a rape advocate specifically for people with disabilities.
Mhm.
And one of my clients at the time, she was about almost 30 years old, but with an intellectual area around 16, and still kind of giving consent, but wasn't giving consent, was taken advantage of. Going through court myself with this individual, you can see that the courts can be very traumatizing because they began to attack her. They began to question her credibility, saying that she wanted it, she just doesn't remember it, to where the client had freaked out. On the stand, threw up their hands and said, sure, whatever. I just want this to go away. And of course, he never saw jail time. And so that is kind of what happens to individuals within the courtroom is that while the person has the right to look at the person accusing them and challenge that accusation, it can also be so traumatizing that that person will then, because of the power control dynamics, want to back down and being re-victimized again.
You also had mentioned, and I know you'll probably get to it in the bias portion of the presentation, but there are certain assumptions, not just even competency, that the court makes in regards to people with disabilities experiencing domestic violence, such as, or sexual violence, such as what comes to
Mhm.
mind, Jocelyn? For me,
So there is an assumption. Yeah, there's a wide assumption that people with disabilities are not sexual beings. And so,
Mhm.
therefore, who would want to enter into a relationship with that individual? People with disabilities don't want families. Why would anybody want to enter a relationship with them? And so, again, there is this mindset that people with disabilities don't desire the same things that everybody else, and that vice versa, person without the disability couldn't possibly desire or want to be in a relationship with somebody that's with a disability. And
Mhm.
so there is that thought process, which I will never say this word correctly, but it's infantilization of a person with disabilities, that we think of them not as a 20-year-old, but a 5-year-old who does not have that kind of expression that all the other
Mhm.
non-disabled individuals have.
And I see that being problematic. One very obvious one is making the assumption that the individual can't parent. So why are you having
Yes.
sex? You know, some it seems really outlandish, but it happens, and it's happening so much. And it rolls into this DV environment where you have a person with a disability being perceived as less than, and now coming in as a victim and even being traumatized all over again, but minimized, the act that occurred on them being minimized.
Yes.
Right.
And then the one thing that I think that's an important to think about when we view DV cases is this person may have started off in this relationship without a disability, then inquired it during the relationship, and now is a person with a disability. And
Mm-hmm.
so we don't often think about that when we look at DV, but the rate of violence, and if it's not physical, it's the mental, which we also know that can create PTSD and other mental health conditions, to other conditions from being an autoimmune, just being in a relationship that has DV in it.
Yeah. And you said something earlier because I'm trying to tie it all together with what we last spoke about, maybe the last session or the session before that. Different types of disabilities. If you take those different types of disabilities and then you put it under the power and control lens, right? It seems to me taking away a diabetic, which is a disability, their insulin, right, which weakens that individual, can be a domestic violence circumstance, and I would say it is. Treating the individual um, as a child, ordering them, it's psychological. That's an abuse. So it's being able to see all of these connectors when the decision maker, especially the judge, is making a determination in a case and assessing credibility. It is not the she said he hit me and he said he didn't. It's looking beyond the obvious that's coming before the court and making a
And
determination
that's where
as
a
to
lot
this
of coercion
person's.
comes in, and Washington State did update that definition to add coercion in there. Coercive control is
Yeah.
something that's really used within domestic violence situations. Within family law, we see a lot of domestic violence situations coming. The problem that we're seeing, though, is once disability is in there, the abuser can and often retains custody of those children because disability then is now mentioned, and you're not parentally fit once you have a disability.
Right.
Um,
Which is
and so
wrong.
it is wrong, and it's changing the more we talk about it. And so, we also look at the intersectional portions of it, which also Washington State doesn't track either.
Mhm.
But we do know that LGBTQI survivors with disabilities experience elevated DV risks too. And
Mhm.
so these are data points that I think that are going to be important for the state to start tracking. Native women are disproportionately represented in DV fatalities. Also not being tracked because we're not looking at it the same. Economic inequities. Disabled survivors are usually, not always, but a little below the poverty line. And as you said, Justice Whitener, then they can't secure housing because of their disability half the time, because of limited housing. Also, I think it's one data area that we are tracking a little more than the rest is Black women in Washington State are also killed by intimate partners at a disproportionately alarming rates. So these things are very complicit. When we look at the court's implication in all of this, intersectionality needs to be operational in everything that we do, meaning courts need to consistently provide interpreters, cultural competence, fee waivers for indigent survivors. And then and I know we talked about this before, but my personal belief is that once you enter in a DV situation, we should be treating all of those individuals with reasonable accommodations and should just
I
give them
like
a
that.
temporary disability status while they're going through the court process.
I like that idea. I never thought of that until I worked with you on this task force because domestic violence in and of itself creates a disability. It could be a physical disability. Most of the time, it's physical and mental. The person that you're seeing in court is not the person, but for the domestic violence. So at the time we're dealing with that individual, that person is undergoing a disability. Never saw that before. And opening my eyes to that, I realized there are many people we're missing providing service to because we see them as normal, so you're normal. You just happen to have gotten slapped or choked or raped, blah, blah, blah. But you're normal. No, you're not. You just went through a traumatic experience. And at the time you're before the court, you're under that traumatic experience. So you're a person experiencing a disability. If he broke your
That's
arm,
yeah.
that's a temporary disability, right? So I just think you're so right on that. And we gotta work on that further after this. But definitely, that is just huge for me. All right, Justin.
So we're going to move a little bit to the barrier survivors face, and one of them is also, yeah, as we mentioned, is entering the court process. We already know it's stressful if you don't have a disability. Add on other layers to that, and it feels like insurmountable barriers that is hard to adjust to. And I know Justice Whitener, you and I just spoke about the implementation and court biases that we wind up dealing with in the courts. And I know we'll go over this slide really quickly, but seeing as non-sexual individuals, people with disabilities are often minimized in courts. Before I got all my diagnoses, as many of us can attest, you're diagnosed with totally different things until you finally find the right diagnosis. And in my youth, I was diagnosed with a learning disability. That was all it was classified as before what we landed on now. And I explained to somebody I had a learning disability. And they said, that's very unusual. You don't seem stupid. You seem like you can hold on an intelligent conversation. And I was shocked by that because they literally had a lack of understanding
Mm.
on what a disability could mean. It had nothing to do with my intelligence. But this is the thought process that we wind up going into. Again, we go back as seen as dependent. People with disabilities are often seen as dependent. So credibility as parents or caregivers is always in question. And then the biases, erases experience of sexual violence, reproductive coercion, and DV. Reproductive coercion is also not allowing somebody to have a family. The courts might say, hey, you're not competent enough to have children, and so therefore you could be sterilized. And so there's a lot of areas within that allows for individuals to experience a lot of bias in the courts.
You know, one of the things I've always been asked since I got to the Supreme Court is how I see things. And I always say I see them through intersecting lens. I'm listening to you. Credibility. Black women have less credibility, there's statistics to support it, less credibility when they report these type of offenses. Native Americans, less credibility. Women, when they report these. So you're already disabled, less credibility. Race, less credibility. LGBTQI, less credibility. Tick, 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 tick. So you start, you know, person, an immigrant, language access, less credible. They don't know what they're talking about. Or stereotypes about their background are brought into play. Oh, they're used to that. I mean, I guess training is the only way to address this with some individuals and make these, for me, clearly strong assumptions about somebody's worth.
Yes. A lot of training, a lot of just
Hmm.
undoing the, racism and ableism that sometimes they don't realize that they're doing. And ableism was one of those into things that still in today's society is very acceptable to do, unfortunately. And it's just working past those conversations and redoing what we think disability looks like. And so some of the barriers, and I know we briefly talked about it, so I'll go through this quickly. We found that less than 30% of domestic violence shelters are fully accessible for disabled individuals. Online barriers, DVPOs, forms, and e-filing platforms are often not screen reader compatible or in plain language. Um, and then what? I am terrible at acronyms or even trying to pronounce them. So, Washington State Coalition Against Domestic Violence had a 1 day census in 2024 that showed 482 requests for help went unmet in a 24-hour period. But I also want to highlight men in this area too, because they have a little bit of different barriers. They have a stigma that's not quite addressed to women and people with disabilities, and that is there is a stigma on men being abused. They are deemed more stronger, more fit. Why didn't you fight back? Why didn't you do these things? And so there is lack of services in DV shelters for men, and disbelief when men disclose their abuse. And so we're running into that. So if you're a disabled man in a wheelchair who's being abused by their partner or caregiver, there is no place for them to go because DV shelters for men are very, very minute.
And this brings me, maybe I intersect things too much, but I can't help myself. Um, it seems to me the problem men who are battered face are the same as women. And the analogy I have to that is what you told us at a previous session, and that is why are we making assumptions, right, about someone's disability, requiring them to document something for us to believe them? It seems to me it's the same situation here. Why are we questioning what somebody is saying happened to them where they have they literally have proof. Many times they're walking around with the proof. The difficult one is the mental stress that they're placed under. And why are we not being more supportive as opposed to being more investigative? It's one thing for law enforcement to investigate it, but then when you pass that in the system, why are we doing that? This is not I ain't expect an answer. I want everybody to just think about it. Why are we doing that? Because if you're not in the court, you might be in a organization that deals with people with disabilities and ask yourself, why are you doing that? Because they would not be asking for help, whether it's the court or not, if they did not really need it. Because I don't know anybody who wants to admit they got their face beaten, they got their dog killed, they got hurt, their kids were subjected to observing them get stabbed, all the different scenarios you can have. What, making it up?
Well, and one of the things that we can look at too is accessibility should be from the start when it comes to DV situations. So that starts with the officer. making maybe a questionnaire. They have a lethality assessment that is often used in severe DV cases. Should their assessment be also including somebody with a disability in there, or should they be perceived as temporary disabled from the start so they can get services from the start once that intake call is given? And when those things are not accessible from the start, I can tell you reason why we have a high 75% that go unreported because it's exhausting. You want me to go through this paperwork. You want me to keep telling you my story to 5 different people, then in front of the judge, and then in front of my abuser, who then could object to everything that I said. And then I've got to prove my abuse to you so that you can be seen as I can be seen as a credible individual. And so that's a lot of things that the court goes through. It's requesting proof, which can sometimes be invalidated if you're going through a civil domestic violence protection order. Re-traumatizing barriers are a lot higher to reach. And so that's kind of some of the issues that we're running into, and why DV does not go any further than sometimes report and doesn't always make it to court.
Yes. And sometimes when it makes it to court, the individual pulls out, recants the story, no longer wants to go forward. And you, as the judicial officer and the prosecutor and defense counsel, because I've had all three roles, have to really pay attention to that scenario. Even when I prosecuted domestic violence cases and I had a recanting victim, sometimes I had enough to go forward without the victim because there are things allowed in the law. The 911 call she made, excited utterance, is an exception. I get to play that. The fact that at the time, the observations around her neck, there were marks. Even the 911 call in regards to how she is speaking, very hoarse. It's because of what happened. So you bring in other people to lay that foundational background and you pursue the case, prosecutor. As a defense attorney, you sit down with your client, and even if you end up getting this individual off because the oath you take is a little different, I always try to educate that individual of how not to do this again and how not to end up in the system again by providing them with various services that are out there to control their battering behavior. And as a judge, is looking for the signs and trying to minimize the trauma in the courtroom that we're putting victims under. Because what you explained, Joslyn, is a re-victimization of the victim. And we're not supposed to be doing that. Now, having said that, you do have scenarios where victims who have been victimized quite a bit then become the victimizer, the batter, the one who is utilizing the system to control the individual. So they have flipped the power and control dynamic. But I'll tell you, those are rare. And there are criminal charges that can go with that, making a false report. So we, as a criminal justice system, need to stop questioning people's credibility in regards to their story. Let it play out. But we start
One
from
of
the premise that they're telling us what occurred.
One of the areas I'd like to touch on too that we haven't been talking about enough is also there is a lot of data out there that police calls up here. It says DV calls as a
Mhm,
mental health or disturbances. So they're also not categorized correctly when it comes to somebody with a disability.
mhm.
But also they fail to document or photograph injuries when disability complicates reporting. Don't provide interpreters. That is something that we're facing here in Washington State is we still have a shortage of interpreters, so they're not often provided in a timely manner. The other thing that we should talk about too is your disability then can be weaponized within court. Again, used against you for credibility reasons. So not only are you being abused in a situation, you're being abused in court, and now your disability is being weaponized against you within the court process.
I
The
see a
other,
parallel, Jocelyn, with rape.
yeah.
Right? Everything you just said there, I just see a rape victim as well. So it seems there's a correlation between the two as well.
Yep. And then we also look at, and I want to bring this statistic up, a national resource that actually shows women of color with disabilities are more likely to be arrested themselves when seeking DV protection. So it flips onto them because we like to believe that angry Black women are the
Mm-hmm.
perpetrators. And so then they're the ones that are more likely to be arrested in DV situations instead of
Mm-hmm.
the other way around.
Mm-hmm.
And so we see that often too within the data that we review. A lot of issues that we still run into is, again, credibility, rushing through court proceedings because there's a backlog. When also people with disabilities aren't believed in court about their DV experience, their homicide rate goes up by 500%, especially if there's a firearm within that household. And so these are not small, I hate using the word small potatoes here. This is something that is huge, especially then when you don't want to disclose your disability because you know it's going to be used against you in court. You're going to be viewed as crazy. They're going to paint you in a picture that you're the abuser because of your disability is now going to be used against you.
And there's this misconception of what a protection order can do. On my DV cases, and a lot of them were in district and municipal court, because by the time they get to Superior Court, they already have much of a history. But when the request is made for a protection order, I always advise the individual that received it that I'm signing this protection order. It's going to prohibit this individual from coming within so many feet of you, at your work, etc. But I want to make something very clear. This is a piece of paper, and you'll have to serve it on law enforcement for it to become something they can act on. But I also want to tell you something, and I said it on every DV protection order case. This will not stop a knife or a bullet. So first and foremost, you need to create a safety plan. You need to document everything where there's a violation or where there's concern from you or where there's a criminal act. Document, document, document. But this is a piece of paper. And the reason I'm telling you what to do with this piece of paper is because the minute it is served on this individual, there will be an escalation. It is where it stops them, it irritates them, and they get escalated in their bad behavior. So it's really important. Safety plan, understand what's going to happen. So set everything up and get it served and protect yourself.
I know that we have about 10 minutes, so I'm going to run through the slides
No way.
relatively quick. Yes, relatively
It went that
quickly here.
fast.
Just to give you a highlight over a high view over or what we're going to be talking about just quickly is the accessibility challenges. As we've spoken, courtrooms still aren't physically accessible for the most part. There's still man-made barriers that we're finding within the way. Braille materials are hard to
Mhm,
come by still. ASL interpreters are a shortage across the state, not just for judicial, but executive, legislative. We're just in short supply.
mhm,
Remote court hearings have helped here in Washington State when we go through DV courts.
mhm,
They are now remote. You can still choose to appear in person, but you now have the choice. And that was from COVID. That's going to stay that way, as you do not have
yeah,
to appear in person for a DV
mhm.
case. And
That's
then
funny.
court accessibility challenges for neurodivergent disabled survivors.
Mhm,
Sensory overload. Courtrooms are sensory overload, I think, for anybody, even if you don't have a disability. But when you compound that
mhm,
to trying to figure out, because you're going to be pro se, which means you're self-represented, and trying to navigate that through a DV situation and the paperworks and the filings and the people you have to talk
mhm,
to can become too much. And again, questioning credibility is just huge barrier
mhm,
for people with disabilities. Um,
Wow.
and then challenging survivors face in court too, credibility issues again, um, ableist biases, skepticism. And then we're going to highlight this one a little bit, is caregiver abuse and shelter access. So
Mm,
many disabled survivors depend on caregivers for the most part. And we do know that those rates are underreported for the most part. And trying to get that data again is very difficult, but we do hear what the survivors are facing. And so most DV shelters are not fully accessible. And again, what abuse could look in that situation is withholding medication, withholding money, withholding certain things. And so
transportation.
it's not just always a physical. Yes.
Hmm. Hmm.
And then strengthening legal protection through a disability justice lens. What can that look like? And part of that is
Hmm.
disability justice means centering those the most impacted. So disabled survivors, what can we do to make the system more user friendly in that aspect when they're trying to go through something very traumatic? Universal design for a court process. We are an ununified court, and so that's what still makes it difficult, is what Clark County does is going to be maybe different from what King County does. And so we find that those add additional barriers
Hmm.
to individuals within the court system when it's not unified.
Hmm.
Addressing civil rights violations. Many DV cases involving disabled survivors involve also civil rights violations too.
Hmm.
And what does that kind of look like? Underreporting of abuse is widespread fear of institutionalization. We do know that that does happen within an institution. Disabled survivors of color are more likely to be institutionalized instead of supported, and then strengthen DOJ oversight. So that is some of the things that
I'll
trying to
tell you,
address when it comes.
Jocelyn, they're going to regret you and I getting together on this because there's work to be done and we're going to be doing it. Because I am getting so many different knowledge-based, um, what's the word? Knowledge-based information that should be able to assist us in making our courts better. I'd love to make every institution, every firm, that'll be on the list too. But this has been such an informative experience for me, learning about disability justice through the work that you have done with me for the court. And I can't thank you enough. I honestly
Thank
can't
you.
thank you enough. I almost
I
miss trial
appreciate
court now.
that. Well,
Yes.
and one of the things that I think is important within the family court setting, so superior court, is that custody and parenting plans, custody can be weaponized against disabled, survivors of abuse, and we're not recognizing that.
Mhm.
The other thing that we're not recognizing is often in DV cases, because you're not, even if you do have a disability, reasonable accommodations are still not offered to you. And I think that is one of the things that a judge needs to do in these situations is, do you need an accommodation
Mhm.
to proceed with this? Because it is re-traumatizing for individuals.
I'll tell you this, I don't remember ever receiving any training whatsoever on domestic violence other than when I was in a Rule 9 with the City of Tacoma Prosecutor's Office back in the day, and they had DV advocates at that time. And I would follow them around on various cases, right, and learn from them. And then funding became an issue, and the first thing they cut was the DV advocates. And I don't think they ever replaced them. So I wouldn't be surprised if things have stopped literally in time with where we were at and how we deal with this population, and then add disability on top of that. Ooh, we got
Yeah,
work to do.
and lots of work to do. Call to action for us is understanding how disability and domestic violence intersect together. So this is not just a court thing. This is an everybody thing, community partner
I
thing, is
agree.
how do we talk about disability and how it intersects with domestic violence?
Yes.
And because again, as we've always said, we're the last stop. And so what can we do in the process before it comes to the court or work together because usually these things happen at simultaneously. Some of the things, besides training more court personnel is just ensuring gender affirming, culturally competent legal services that include every aspect of an individual. Strengthen enforcement and accessibility, improve DV shelters accessibility. Obviously, everything requires more funding. Faster emergency response services, training again for law officers to understand what and look for, is this person a person with a disability? How can I ask these questions without them disclosing? Which should flag this person needs additional resources
Mhm.
because a lot of resources are given are not with disability in mind.
Mhm.
And again, we're not tracking. We're not creating data. We don't have anything to kind of definitively see the numbers in a large term except for national evidence. And then
Mhm.
identifying survivors' needs. Again, I just mentioned that is what do you need to work through this process? Because this is a scary process. As data shows, leaving a partner or a domestic violence situation, your lethality rate goes up quite drastically.
I
Um,
I agree.
and yeah,
The
it
statistics
is.
support that for sure.
Yeah. And
So,
then community
Jocelyn,
partnership.
go ahead.
Yes. Um, Community partnership, courts can't do it without your help too. Referral
Mhm.
pathways, courts can't connect survivors with advocates for safety planning or housing and support. Joint training, so something that judicial, state, executive branch can do together. Cross training between courts, law enforcement, and DV disability programs to build shared understanding. How can we work this together? As you've heard, Washington State has a domestic violence problem
Mhm.
and it's not dwindling, it's actually increasing as time goes. And then consistencies across county partnerships reduce the luck of the draw problem. Some counties have more money than others, so therefore you may get a little bit more help. And then accessible community services, shelters, hotlines, advocacy programs, and then survivors often disclose to advocates and police sometimes about their disability too. So that's something to kind of consider. And then naturally, always strengthen the ADA
Mhm.
compliance that we have around there.
Which
And
should be the
that's,
floor, not the ceiling.
yes,
Mhm. Okay. Questions, anyone?
there's some
Oh,
in there, and I can,
Are there some?
okay, Jocelyn, if you're going to cover them, that's fine.
yes.
Mhm.
So what does parental plans look like to keep a victim safe? I can answer a little bit of
Well,
that if you like,
okay.
Justice Whitener. Part of that is to if domestic violence has been found either civil or criminally, to build that into your plan. So require them to do domestic violence, not training. It's a domestic violence, get help for domestic violence in their anger. They'll have to go through a whole series of testing to see what level they might be. So if they're level 3, it's mandatory up to a year with compliance reports added in. You can also require psychological exams to make sure that that individual is going to be safe with your individual child and or if there is parenting classes to supervise visits. So there is some areas in there that you can kind of build into your plan.
And that's the community focus from the law. The judge can impose protection orders that limit contact between the two individuals. If there isn't that concern necessarily, the court can also monitor underlying issues such as controlled substance issues, alcohol issues, gambling issues, all kind of issues a person can have that is literally what they're using as the crutch for why they are abusing. The court can also put in place violation limitations, such as you don't get to go in particular areas if that's going to be affecting your other treatment. Um, you have to go to get a batterer's assessment and follow any recommendation that they make. But most important for me, I used to add, you have to disclose your criminal history because I do know that the individual who's providing the treatment needs to know who they're dealing with. And you'd be surprised how many go in and say, this is the first time this ever happened to me, when I'm looking at a criminal record that shows it's quite a few years and quite a few times. And when I see that, I already know they have not been arrested for all that they've done. They've just been arrested for those that were called in. And as you've heard from Joslyn, they don't call in all the time. So, from the court perspective, we're trying to address the batterer's condition, if you want to call it that, or behaviors during the pendency of the case that we have.
I would like to add one note that Washington State does both on the criminal and civil side is electric monitoring. And it's
Hmm.
relatively new, and only two counties are taking full advantage of it. Is that you can ask the judge, depending on the severity of the DV case, for them to be electronically monitored. And so if they come around your home, you get notified, the police get notified, they get notified that they've entered a no-go zone, and their electric monitoring will start loudly emanating a loud noise of a ring or a beep, notifying that. And the monitoring place actually tracks their entire move to make sure that they are not within your recommended feet that the judge has set.
Right, exactly. And that has always been there, but never used for DV cases. We can always require, as one of the conditions, be on electronic monitoring as a condition of your release. But I'm glad to see that they're using it now if we're going to release you, which makes sense sometimes because these individuals, the victim is dependent on the batterer for housing, for funds, for food, all those sorts of things. And if he is in prison or in jail, that gets cut before she's ready to deal with that. So sometimes electronic monitoring, but you got to stay somewhere else, helps. And the fact that they're monitoring them that way makes sense. Let's see what else we have in there. What
I
are the
think we're
options?
at time though, Justice. Yeah,
Oh, I am so
it's
sorry.
11:23, so
Great.
we are considered at time. We had to end a little bit early because of a conflict.
Oh, oh, okay. Sorry, I was
So,
really getting into this. I always get into this. Thank you so much, Joslyn. And thanks everyone for coming. And as you can tell, we're not finished yet. We'll keep working on this with your help. If you have ideas, if you want to be part of anything that we're working on and you get notification about it, please reach out. But we're not giving up. We're going to try the best that we can to kick down these barriers in regards to how we deal with individuals within our courts who have disabilities. Thank you.
yes, thank you, Jocelyn and Justice Whitener. And what we will do is what we've done in times past. The questions that we weren't able to get to, Melissa will work behind the scenes to get answers and then email that out to everyone. Thank you all for joining, and thank you too for coming back again and sharing your knowledge and expertise in this area.
Thank you. Bye.